This is a replay of Let's Talk Nigeria on Sparkling 92.3 FM Calabar, making Nigeria better, one conversation at a time.
We talk everything. Health, education, finance, sports, transportation, agriculture, politics,
entertainment,
people and power on Let's Talk Nigeria. Let's Talk Nigeria. Every day of the week from 9 a.m. to 10 a.m. Only on Sparkling 92.3 FM Calabar. Your radio, your shine.
Hello, welcome. It's time for Let's Talk Nigeria on the Sparkling Morning Show on Sparkling 92.3 FM Calabar, Cross River State, Nigeria. This morning, we continue from, there's been several reactions to the state of emergency declaration by the president and also the suspension of the elected governor of River State, Mr. Siminalayi Barr, and his deputy, and also the lawmakers of the River State House of Assembly. Yesterday, several reactions poured from prominent Nigerians, and in the course of this conversation, we'll take them one after the other before we get connected with our guest this morning. And also on today's Let's Talk Nigeria, we'll get to look at the recall process that has begun for the Senator Natasha Akpoti-Uduaghan, and on what grounds the Constitution provides for a recall of a senator and the procedures to follow to make that happen. So this morning, I will start off with the reaction that came from the chairman of the Labour Party Caretaker Committee, Senator Nenadi Usman. What she said yesterday, I'm going to read it. She said, "Today I join all well-meaning Nigerians to vocally condemn President Bola Tinubu's recent declaration of a state of emergency in River State, which includes the suspension of Governor Siminalayi Barr, his deputy, and all elected members of the State House of Assembly." Now, this action represents a blatant subversion of democratic principles and an affront to the constitutional framework that underpins our nation's democracy. The suspension of duly elected officials undermines the right of the people of River State and sets a dangerous precedent. While concerns regarding pipeline vandalism and political unrest are legitimate, the federal government's unconstitutional and heavy-handed approach is not the best way out. Addressing such issues requires adherence to the rule of law, constructive dialogue, and collaboration with state government, not the imposition of authoritarian measures. I wish to call on the federal government to rescind this undemocratic declaration, reinstate the suspended officials, and engage in meaningful dialogue to resolve the issues in River State. Nigeria's democracy has been hard-earned through the sacrifices of countless individuals who we must not allow it to be compromised by actions that contravene the very principles we strive to uphold. And this is from Senator Nenadi Usman, chairman of the Labour Party Caretaker Committee. And also, we also saw Malam El-Rufai coming out to speak on this same thing. He said the Tinubu-led federal government should restore elected officials in River State. And I read what he said. There are things that are so clearly wrong that the justifications summoned in their defense fall flat. The decision of Mr. President to suspend the elected officials of River State government is one of those. Our constitution does not support it precisely because it is dangerous to our system of democratic federalism for an elected president to assume and exercise powers to suspend elected officials at the state level. The responsibilities of a president are heavy and extensive, but they are constrained by the Constitution and the law, and certainly do not include firing persons who were elected. He went on to say the security issues cited in the president's speech surely deserve the most serious attention and sustained effort to contain the threats and preserve vital national infrastructure. This is a duty that we ought to vigorously support the security agencies to successfully discharge. A state of emergency could surely have been proclaimed to grant the relevant security agencies the extraordinary powers and necessary resources to enable them address the problem. Extending the provisions of such an emergency regime to include the dismantling of democratic structures is a wanton aggression against democratic tenets and the rule of law. The Supreme Court has conclusively declared the suspension of elected officials unlawful in the Dariye versus Attorney General of the Federation. It is my view that the President should review this decision and return to the path of constitutionalism and the rule of law. As an opposition figure, Senator Bola Tinubu had made his voice heard against the decision of the then President Goodluck Jonathan to declare a state of emergency in the Northeast. Even when that decision did not extend to the suspension of elected officials and institutions, a similar reconsideration is warranted in this case to contain the damage done to the people of River State and restore the federal government to compliance with the Constitution. Let's not keep silent while the slippery slope of replicating the events of emergency rule in the Old Western region in 1962 unfold before our very eyes. I appeal to all patriots and voices of reason to join in calling an end to this gross violation of the Constitution and disrespect for the rule of law. Malam Nasir El-Rufai, CON. This was yesterday. Okay. Now, some people came out to say if El-Rufai was still in the APC, would he have made this statement? Okay. So let's also look at what Peter B said about this. He said the unilateral decision of President Bola Tinubu to remove Governor Siminalayi Fubara of Rivers State is not only unconstitutional but reckless. It has plunged us back into the state of lawlessness, hugely undoing the progress we have made in these 26 years of democratic journey. By disregarding the rule of law, the president has shown a dangerous willingness to trample on democracy. The declaration of a state of emergency in River State is not just reckless, it is a clear attempt to return us to a state of nature and tighten its grip on power at all cost. And he went on to say it is a degrading backdoor imposition of martial rule on the strategic part of the Federation with all implied negatives. The political situation on the ground in River State does not justify such an extreme measure, and it is also biased interpretation of Section 305, subsection 1 of the 1999 Constitution. Now, people, I'm not done with reading this, but there have been a lot of reactions in the interpretation of this Section 305. And in the course of this conversation, our legal practitioner will join us to also help us understand it clearly. Some people are asking, should the National Assembly had given the approval before the federal government went on to declare a state of emergency and appoint an administrator, or after? So these are really dicey issues, and the legal practitioner will do justice to this. But the reactions are still pouring in, and Nigerians are still reacting to this. And we'd also like to hear your reactions to this very salient matter that is still ongoing. And the thing about this is that this particular happening has overtaken a lot of events that we have seen in Nigeria. This is what is in the mouth of almost everybody in Nigeria: the state of emergency, the removal of the elected governor, the deputy, the lawmakers, and all of that. All right, I'll continue with this statement. A state of emergency does not mean an elected governor can be removed unilaterally. This decision does not align with democratic norms or good governance. Instead, it appears to be a predetermined action serving specific interests rather than the collective good of the people of Rivers State and Nigeria. This action constitutes an unconstitutional overreach, setting a dangerous precedent that threatens democracy, the rule of law, and separation of power. If left unchecked, could foster a culture of impunity. Having already been grappling with non-adherence to electoral qualifications, rules, and massive rigging, adding arbitrary removal of elected officials will push us to a state of nature and anarchy. I appeal to the National Assembly and all stakeholders not to allow this to stand, as it only deepens the culture of impunity and brigand already threatening our democracy. So this is from Mr. Peter Obi. And also yesterday we saw the reaction from Mr. Rotimi Amechi, where he said that this is illegality and it should not be allowed to stand. And several others have also lent their voice to this. We saw the likes of Dele Momodu coming out to say, instead of calling Wike to face his assignments in Abuja and Rivers State alone, President Tinubu prefers to pamper a troublemaker by throwing away an elected governor. And like I said, several other reactions have come into this. And there are other people like the likes of Reno Omokri who said that this is the way to go and the president is within his right to actually do what he did yesterday by declaring a state of emergency and also suspending the elected governor alongside his deputy and the lawmakers yesterday. I think there was also a report that came out that Martin Amewule said that the president is right to have declared a state of emergency and also to have suspended the individuals that were suspended. And don't forget that yesterday we also saw the likes of MBA. The president of the NBA came out yesterday to speak up about this Mazi Afamosigwe son. And I'm also going to read what he said yesterday in this message he communicated yesterday, titled State of Emergency in Rivers, Suspension or Otherwise, Summary Removal of a Democratically Elected Governor and Other Elected Officials is Unconstitutional. The Nigerian Bar Association has taken due notice of the declaration of a state of emergency in Rivers State by President Bola Ahmed Tinubu as contained in his address. This declaration, according to the president, is due to prevailing political tension in the state and due to the vandalization of pipelines between yesterday and today. This development has far-reaching constitutional and democratic implications, particularly in light of the provisions of Section 305 of the 1999 Constitution of the Federal Republic of Nigeria as amended. Now, this is where a lot of people are, are confused and asking for interpretation. If the NBA is coming out to say that the president did not do well in terms of exercising this right, several lawyers have said different things. Who should we believe? Because the judiciary is there to interpret the laws. The executive implements the laws. The legislature makes the law. Executive implements it. The judiciary interprets it. So if we have several interpretation of one section of the Constitution, it further leaves Nigerians confused as to which one is true. Which is the true interpretation of this Constitution? And if the NBA is coming out to say what they have said, because if the president of the NBA, he's not speaking here as an individual, he's speaking as the president in his office, as the president of the NBA. So this is the NBA actually speaking, and the NBA is an umbrella body of all the legal practitioners in Nigeria. All the SANs in Nigeria all belong to this umbrella. Okay. Section 305 of the Constitution indeed vests the President with the power to declare a state of emergency. The section stipulates strict conditions and procedural safeguards that must be followed to ensure that such extraordinary measures do not infringe on democratic governance and fundamental human rights. The NBA is gravely concerned about the purported suspension by the President of the Governor of Rivers State, the Deputy, and the members of the Rivers State House of Assembly for 6 months. The 1999 Constitution does not grant the President the power to remove an elected governor. I take that again. The 1999 Constitution does not grant the President the power to remove an elected governor, deputy governor, or members of a state legislature under the guise of a state of emergency. Rather, the Constitution provides clear procedures for the removal of a governor and deputy governor as per Section 188. Similarly, the removal of members of the House of Assembly and dissolution of Parliament is governed by constitutional provisions and electoral laws, none of which appear to have been adhered to in the present circumstances. A declaration of emergency does not automatically dissolve or suspend elected state governments. The Constitution does not empower the President to unilaterally remove or replace elected officials. Such actions amount to unconstitutional usurpation of power and a fundamental breach of Nigeria's federal structure. The NBA firmly asserts that the situation in Rivers State, though politically tense, does not meet the constitutional threshold for the removal of elected officials. For a state of emergency to be declared, Section 305, subsection 3 of the Constitution outlines specific conditions including war or external aggression against Nigeria, imminent danger of evasion or war, a breakdown of public order and safety to such an extent that ordinary legal measures are insufficient, a clear danger to Nigeria's existence, occurrence of any disaster or natural calamity affecting a state or a part of it, such other public danger that constitute a threat to the Federation. Nigerians, this is before you, so you are the one to make your own decision at the end of the day. The NBA questions whether the political crisis in Rivers State has reached the level of complete breakdown of law and order, warranting the removal of the governor and his administration. Political disagreements, legislative conflicts, or executive legislative tensions do not constitute a justification for emergency rule. Now, many Nigerians have asked, why did the NBA keep quiet all this while and not speak up when they needed to speak? Why are they coming out to speak? I think he explained it in this particular paragraph. Okay, so he went on to say such conflicts should be resolved through legal and constitutional mechanisms, including the judiciary, rather than executive fiat. The purported removal of Governor Barr, his deputy, and members of the Rivers State House of Assembly is therefore unconstitutional, unlawful, and a dangerous affront to our nation's democracy. Furthermore, before I go on, yesterday we saw the Attorney General of the Federation come out to state in clear terms that the President did the right thing. So if the NBA is speaking in this tone, and if the AGF is saying something different, who then should we believe? Who is interpreting these laws according to what the Constitution says? Is the Constitution a thing to be interpreted by individual minds? Or is there one interpretation to what the Constitution says? These are questions that are begging for answers in the minds of Nigerians. Now, he further said, the purported removal, okay, I've taken that. Furthermore, subsection 2 of section 305 provides that a proclamation issued by the President under this section shall cease to have effect if it's not approved by a resolution of the National Assembly within 2 days when the National Assembly is in session. So, people, I think this answers the question that a lot of us asked during the newspaper review, where he said that the National Assembly should have approved it first before the president went on with the declaration. According to what the NBA president is saying, the proclamation ceased to be in effect if it is not approved by a resolution of the National Assembly within 2 days when the National Assembly is in session, or if the National Assembly is not in session within the 10 days after it reconvenes. So the National Assembly is in session as we speak. Yesterday, it was part of their order paper, but they did not consider it yesterday, and we're told that today, being Thursday, that they will consider it. So today is the expiration of the 2 days, the 48 hours that the National Assembly has to consider this declaration by the president. So all eyes are on the National Assembly. We're waiting to hear what they will say at the end of today. And don't forget, yesterday there was a heated argument in the House of Reps between two female House of Rep members. They were really engaged in an argument and war of words. One of the things that they said, one person said, is that everybody clearly heard is who is Wiki. And we don't know the genesis of the problem, but we know it has something to do with the state of emergency declaration and the suspension of the governor of Rivers State, his deputy, and the lawmakers there. All right, we'll go on a short break. When we return, our guest will be speaking with us this morning. This is the Let's Talk Nigeria. Please stay with us.
Chips and salsa. Sparkling 92.3 FM, Calabar.
Calabar's number one.
Number one.
Music, sports, and talk radio. Let it hit on.
Ladies and gentlemen.
Sparkling 92.3 FM.
This is a replay of Let's Talk Nigeria on Sparkling 92.3 FM Calabar, making Nigeria better, one conversation at a time.
We talk everything. Health, education, finance, sports, transportation, agriculture, politics,
entertainment,
people, and power. On Let's Talk Nigeria. Let's Talk Nigeria. Every day of the week from 9 a.m. to 10 a.m. Only on Sparkling 92.3 FM Calabar. Your radio, your charm.
Welcome back. Still Let's Talk Nigeria on the Sparkling Morning Show. Still talking about or receiving the reactions from Nigerians, some prominent Nigerians, about the state of emergency declaration by the president yesterday. And this morning we're being joined by Barrister George Akiki. Good morning to you, Barrister. Can you hear me?
Yes, good morning, Ukamaka. I can hear you loud and clear.
Thank you very much for joining.
Morning,
Yes, so some Nigerians have been asking, and even on our program this morning, some people have asked about the declaration of the president and the removal or the suspension of the elected governor and his deputy and the lawmakers. Should the National Assembly had ratified that or had approved that declaration before the president went on to declare it, or should it be after? There's a lot of confusion around that. Can you help us make sense of it?
Okay, Ukamaka, the issue of the declaration of the state of emergency by His Excellency the President and Commander-in-Chief is not a strange activity. However, it must be done within the ambit of what the Constitution provides for. So if you look at Section 305 again, you see that the provisions are clear. First, Sub 1, subject to the provisions of this Constitution, the President may, therefore means that the President can. The word may is a word that is used alternatively. The president may decide to. The president may also not want to, but the president can. Now, but then the provision says the president may, by instrument published in the official gazette of the government, issue a proclamation of a state of emergency in the federation or any other part of it. Nobody is taking a cognizance of that other part that says or any other part of it. Don't forget that if you look at section 1 or section 2 of the Constitution, when we talk of the Constitution of Nigeria, we're talking of Nigeria as a federal unit, talking about the 36 states and the FCC. So when it says any part of it, it says you will be talking about any component part of it. But then now, the second part of it, which has answered the question of what should have been done first. Is it the National Assembly ratifying it first, or is it the President be carrying it out first? The second part of it says, President shall immediately after the publication transmit copies of the official gazette of the government or the proclamation containing the proclamation, including the details of the emergency, to the President of the Senate and the Speaker of the House of Assembly, each of whom shall forthwith convey or arrange for a meeting of the House, of which he, the President or the Speaker, as the case may be, to consider the situation. So the first thing is make the proclamation. I don't know if you're hearing me, Kamaka.
I can hear you.
Good. Make the proclamation. And after making the proclamation, forward copies of the content of that proclamation to the National Assembly, both houses, for a deliberation, where they will now decide whether or not to pass a resolution approving. So when there is a proclamation first, and then there is an approval, so that is the procedure.
Okay, so with what you said now, the president is within his right or has done what he did within the ambit of the law, from making the announcement or proclamation in a federal gazette and then transmitting the publication to the National Assembly. Now, according to these are two issues now.
Okay. The issues I know Nigerians are clamoring for. It's not the issue that the president cannot make a proclamation. What Nigerians are clamoring for is, in making such proclamation, can you alter the period of service of an elected officer? That is what Nigerians are clamoring for.
So, what do you think? Is the president within his right to do that?
Well, these are two clear issues. The provisions of the Constitution, again, we go back, has given us the instances where, or the grounds for which you can remove an elected officer from office. Exactly. If you look back at history lane, this is not the first time the representatives have been declared in state. But you will remember that none of the elected officers were asked to leave office or were suspended from office. So why everybody is
really there was a time during the Obasanjo's era that he did the same, but during Jonathan's era he did not told that part.
The Obasanjo era happened on grounds of I think insecurity at Adamawa State. 3 states were involved. Adamawa, in Borno.
No, that's Jonathan's time.
Okay, that's Jonathan's time. That's the Jonathan's time. The truth is simple. When it has to do with position of elected officers, there is always a procedure for their removal. So, at any point you're considering seeking a process of removal, you should always revert to the procedure of how to remove. If we look at these provisions again, within this period, there is no place that says the elected officer of that is occupying that office could be asked to be suspended or can be suspended. Don't forget that also the governor can recommend that the state be declared to be declared. So I think Nigerians should just let's hold on it's going to go through the National Assembly. When it gets there, every Nigerian has an elected officer, either as a senator or as a member of the House of Reps, who is supposed to speak on your behalf. So let's allow the Senate to do their work, or the House of Reps to do their work. Of course, I know so many people will get back to me and say, well, you know that this is a rubber stamp, but I don't make such comments. That is number one. Number two, assuming the National Assembly doesn't get it right, of course, there's another avenue also. The court is there. So, but I feel that at this stage, this is just the beginning process of this entire activity. But suspended from office. So why everybody is
Okay,
really
there was a time during the
and making
Obasanjo's era that he did the same. But during Jonathan's era, he did not told that part.
The Obasanjo era happened for this on grounds of I think insecurity at Damawa State. 3 states were involved. Damawa, in Boronu.
No, that's Jonathan's time.
Okay, that's Jonathan's time. That's the Jonathan's time. The truth is simple. When it has to do with position of elected officers, there is always a procedure for their removal. So, at any point you're considering seeking a process of removal, you should always revert to the procedure of how to remove. If we look at these provisions again, within this period, there is no place that says the elected officer of that is occupying that office could be asked to be suspended or can be suspended. Don't forget that also the governor can recommend that the state be declared to be declared. So I think Nigerians should just allow. Let's hold on. It's going to go through the National Assembly. When it gets there, every Nigerian has an elected officer, either as a senator or as a member of the House of Reps, who is supposed to speak on your behalf. So let's allow the Senate to do their work, or the House of Reps to do their work. Of course, I know so many people will get back to me and say, well, you know that this is a rubber stamp, but I don't make such comments. That is number one. Number two, assuming the National Assembly doesn't get it right, of course, there's another avenue also. The court is there. So, but I feel that at this stage, this is just the beginning process of this entire activity. But of course, everybody reserves the right to make their expression. But the expressions as raised, I think we have considered what the law looks like and how it can be applied.
Okay. Barrister, you said something, because all eyes are on the National Assembly. Today is the expiration of the 48 hours. And from what you said, the president is within his right to declare a state of emergency, but there are procedures for removing or suspending a governor, which, from what we have seen so far, that wasn't followed. So what if the National Assembly goes on to ratify that when they are aware that there's a procedure for removing a state government?
If the National Assembly goes ahead to ratify the decision of the president, every action of any organ of government is subject to interpretation by another organ of government. And that organ of government started with the duty to interpret is the judiciary. I always try to let people know that the judiciary is not like the executive arm of government or the legislative arm of government, where when one action has been done and that it depends there. If the judiciary takes an action or takes a decision and makes a judgment, it becomes a precedent. So you will observe that at several times when the judiciary is making interpretations or making declarations or judgments, in most cases, if the judgment was not determined with proper consideration of the issues of law, yes, it has gone, of course, to the Supreme Court, and whatever they say is law and it's final. It's because at every new great issue coming up, there is a difference. So all cases are not always the same. So if the National Assembly decides to go the president's way and ratifies it, people of Rivers State reserve the right to challenge it in court. Governor of Rivers State also reserves it as a right, as a person, to challenge the removal in court. Deputy governor reserves the right also to challenge it in court, same with the members of the House of Assembly. So
Okay.
that is the only option they have.
All right. Thank you so much for bringing clarity. Some Nigerians raised.
Hello, can you hear me?
Can you hear
Can you
me?
hear me, Kamaka?
I can hear you
Loud
clearly.
and clear, I can hear you right again.
Okay. So another concern the Nigerians raised is on the issue of what the Supreme Court said about if the budget is not represented to the House of Assembly in Rivers State, the funds for the running of the state will not be.
It's really correct or right is the build-up of each of the cases that is involving the governor of Rivers State and the members of the House of Assembly. However, judgment had been declared delivered by the court, and the parties in that judgment were given certain responsibilities. In that judgment, the Supreme Court said, because you failed to present your budget to the House of Assembly, you could not have powers to spend it. That is how the case is. It's not in the law. Government that is presented to the budget because they have to present it. Because of that, you suspended it. And you know that the proper order.
Barrister, your line is breaking. Can you still hear me?
The issue that's what I'm defending it. So, although they don't really do that, the question is asking as to whether the sole administrator can proceed to make expenditures without any. Don't forget that this proclamation has suspended two arms of government. It suspended the executive, it suspended the legislature. Don't forget that there are no more local government chairmen in Rivers State.
Yes.
Subject to that judgment as delivered by the Supreme Court. So the only arm of government operational now in Rivers State is the judiciary. And therefore, within this period, the issues of compliance of law cannot be oppressible. When I mean compliance of law, also in relation to carrying out executive functions or carrying out executive functions cannot play out because where is the House of Assembly for budget to be presented to? It's not there. So, yes, and of course you're already aware that there have been clamor here and there that there are some insecurity threats booming, growing in Rivers State. And if you consider the statements made by the president, the entire statement from top to bottom, the underlying factor, which of course everybody is subject and interprets the statement his own way, but what I have picked as the underlying factor of this declaration of state of emergency is the anticipation of insecurity. So the only task that the sole administrator must have been given would have been go and maintain peace in Rivers State. He is not go and do projects in Rivers State. I don't know if you're following me.
Yes, I am.
Hello, Kamaka.
I can hear
It
you.
is not go and execute capital project. No, it's not about execution of capital project. It is go and maintain peace in Rivers State and make sure that that part of the state is not under serious insecurity attack. The president of the country has powers to protect the external boundary, external territory of the country, including component units. So that the sole administrator, as appointed by the president, will only go to Rivers State and maintain peace. That is expectedly what it should be. Therefore, in carrying out that responsibility, of course, finances will have to be made available to him. These finances made available to him, I don't believe that anybody should expect that the National House of Assembly should look at it. But then, at this stage, because he's a sole administrator, the National Assembly rather, not the State Assembly, the National Assembly is there to keep an eye on him. Look at his activities and be sure that he is not doing anything outside what he's supposed to do. That's it.
All right. Thank you very much, Barrister
Barrister
Cook. Thank you very much for helping us understand this, because these are thorny issues that require a lot of explanation for Nigerians to actually gain understanding. right? You can be part of this conversation. 0812-723-7060, the number for you to call this morning, or you can send a message on WhatsApp or send it to the SMS box. So far, thank you very much. Now, Barrister, another issue that we have on ground is that of the recall process. We got a report yesterday that some constituents, members of Senator Natasha Akpotudwagan, they started a recall process. And I don't know if we've ever recalled a senator, right? I know that some governors have been impeached in the past, right? But for recalling a senator, I don't know if it has ever happened in Nigeria. So on what ground does the Constitution provide that a senator can be recalled?
Ukamaka, thank you very much. The issues of recalling a member of the National Assembly is provided for in Section 69 of the Constitution. And the requirements are that, one, a petition should be presented to the chairman of INEC on behalf of persons signed by at least more than half of the persons registered to vote in that person's member's constituency where there is that allegation of loss of confidence. I don't know if you're following me. The second activity is that the petition is thereafter a referendum conducted by INEC after 90 days or within 90 days of the receipt of the petition, approved by a simple majority of the votes of persons registered to vote in that member's constituency. And after that, the members shall receive, so those are the two procedures for recalling. Now, what are the grounds for which a member can be recalled? Of course, once, like the Commissioner has said, once your constituent passes the vote of a lot of confidence in you, it presumes that, don't forget that you are elected by these people. And these people reserve the right to say, see, you are not speaking wrong. The mistake we keep making as Nigerians is that we just consider that once the person has won election, let him go and do his 4 years and leave. People forget that you became an elected member of the House of Assembly, of the National Assembly, of the Senate, of the governor, or a chairman of the local government, even a councillor, by the vote of the people who make up your constituency. Therefore, if at any point you're carrying out activities that do not represent the interest of the people reserve the right to say, sir or ma, we don't want you here again. This is not a party thing now. I hope you were following me. Recall of a member of a parliamentarian is not a party decision. So at this point, the Constitution looks at it that, see, you are representing your people. There's a social contract between you and your people. They vote for you, go and deliver or work in their favor. So if you're not seen to be working in their people, they have the right to come back and say, please come back home. But then the question is, has it ever gone through? And the answer is no. The reason is because of the political underlying element that surround our development for our democracy as Nigeria. You can barely discuss any aspect of governance in this country where without people talking about some political undertaking. So already people are already considering, okay, so who are the persons that make up this federal constituency? How many are they? How can we even get there? So some persons will also be making effort towards such attempts. So that's why it is always not very easy to recall a member of the National Assembly. But not that it is not a provision contained in the Constitution. I don't know if I've answered.
All right. Thank you very much for that, Barr. So we have a question here from Nemeka in Federal House, and he's asking, he says, Ukamaka, please ask your guest, is this an impeachable offense on the part of the president assigning the running of Rivers State to himself via the Federal Executive Council?
Is it an impeachable offense? Oh, wow. I'd like to give that answer in a very firm position. Now, let's look at the powers or who the president of the Federal Republic of Nigeria is. Let's even look at who he is by virtue of what the Constitution has elected him to be. The President of Nigeria is like the father of the house. And because of this, the way the Constitution gives him power, because he needs to perform the duty that he needs to perform, Constitution gives him certain powers and responsibilities. And of course, one of it is to maintain peace or law and order, as it has to do with the component unit or the federation. Federation, you mean the Federal Republic of Nigeria, which of course includes the state. And we understand that it's only the National Assembly that makes laws. That is why the proclamation you're seeing here is going to go through a law-making process. But in the process concept of separation of power, we know that the other arms of government too also make certain laws. The judiciary make laws when they deliver judgment. And declarations of this nature form some sub-laws made by the executive. So yes, the president, within his power as the president of the country, can make certain proclamations or when the president of the country on the date of February on May 29 said fuel subsidy is gone. It became a proclamation of the president. What now happens is that every other organ or department of government that is supposed to be involved in carrying out that process, the lawmaking process, is fine-tuned after such declarations are made. So yes, the president making proclamations is within his duty as the president of the Federal Republic of Nigeria. I don't know if I've answered our question or his question.
All right, thank you very much. Nemeka, I hope the question you asked has been answered by the legal practitioner here. I'm not a woman of the law, so we have a legal practitioner. Are you praying that I should go to the Senate? You're already calling me a lawmaker.
Sorry.
Apologies for that. I had to retrace myself. A legal practitioner there.
All right.
But thank you very much. Back to what you were saying about Senator Natasha's recall process. Some Nigerians are asking, why did the constituency have to wait till now before they begin the recall process? All this while she's been there since the ending of 2023. We've not heard any recall process. Why now that she's having an issue because of the suspension and all the sexual harassment allegation? Why now?
So I will answer that question by taking you back to one of the statements I made when I was answering that question. I have said every activity of government, every activity of governance has an interpreted meaning or link to politics. So whatever may be playing out now may be politically induced. You never can tell, but it will have a semblance of politics, because some persons will argue that yes, the constituents have the right to do this at this stage because you cannot lock out a senatorial district from national discussion for such a long period, allowances blocked and everything. So they feel that no, if this thing can keep us for 6 months without having access or without having national representation, we rather ask this man to come back and send somebody else. But what they forget to know is that the procedure for the whole thing to take can even take more than 6 months. I think at this stage, the issues in the National Assembly should be, Nigerians should just give it some cool look. Let the procedure be done. And some that are in court, let's wait for their determination. Of course, there are some actions in court already filed by Natasa Akoti. One alleging, of course, harassment. The other one on defamation by the aides in the Senate President, and maybe any other. Okay, and the other one on her suspension. These are issues that are already subject. They are in court, and like I said, it is not really a good element of democracy to sit down to discuss these issues yet to be determined in court, because you will only end up whipping your sentiments, giving your position, giving your opinion. Can it affect the judgment? Can it instigate public around? Yes, it can. The Senate is conducting its activities. If the Senate action was not proper, the court will say so. And like I said, if the court says it was proper, they have also set a precedent. let me remind you of one very novel issue that took place in the Nigerian democracy. You remember when Mr. Rotimi Amechi ran election as governor of Rivers State.
Okay.
After the primary selected by the People's Democratic Party, Celestine Omehia was declared the winner. And he went into the electoral process. You will remember, you will recall that Rotimi Amechi challenged that substitution by his party up to the Supreme Court. And the Supreme Court in the judgment said, no, a party has the powers to conduct elections. They have the duties to send whoever they have nominated to INEC. But when you conduct your primary, it is a sub-election. Whoever emerges there emerges with a mandate for these people. You cannot remove him and replace him with the person you want. So they declared that substitution null and reinstated Amechi's name and the flag bearer of the party. Now, at this stage, election had been concluded. Ordinarily, people would have said, okay, the Supreme Court was going to say, everybody said, go back and conduct the election now. But because the party is the one who wins the election, Supreme Court simply installed Rotimi Amechi, being the flag bearer, the legally appointed and elected flag bearer of the party, as the governor of Rivers State. But would you be shocked to know that that precedent cannot be relied upon again in Nigerian electoral procedure? Because the Supreme Court has had, at some point, said, or at all times, even up to now, you can only challenge an election you took part in from the beginning of the process to the end.
Okay.
So, when the issue of doctrine of necessity as contained in the Constitution is discussed, Nigerians should also remember that the judiciary or the courts have certain powers to look at grey issues that are not contained anywhere in the Constitution. And in interpreting that law, somehow create a new law that the National Assembly will have to do what amend to suit.
All right.
So that is it.
All right. Thank you very much, Barrister Akiki. Thank you for your time and the explanation this morning. Wait to hear the resolution of the National Assembly on this matter before the end of today. But all the same, have yourself a beautiful day.
Thank you very much. And bye-bye.
Yes. All right, people, thank you very much for today, allowing us to be your companions. We're watching to see the decision that will be taken by the National Assembly, both houses. And until then, maybe we'll discuss it tomorrow. Okay? Thank you very much. Ukamaka Richard Bassi is my name. God bless.
Number one.
Music, sports, and talk radio. Let it hit on.
Ladies and gentlemen.
Sparkling 92.3 FM.